Hi and welcome to our second employment law podcast for local government. We've got some really interesting topics to cover today, including the removal of the default retirement age, which happens next year, and also we're going to look at some of the processes involved in changing terms and conditions of employment. But our first topic today is to look at the agency worker regulations, which come into force on the 1st of October next year. That might seem a long time away, but Phil's going to talk us through some of the main provisions in the regulations and also tell us what councils need to be doing now to help prepare for that. Phil, can you tell us who the agency worker regulations cover and why they will impact on local authorities?
Well, the agency worker regulations apply to the category of workers that we all call temps. They are agency workers that are placed through temporary work agencies in authorities. Now, the regulations are important for local government because we've got a lot of agency workers who perform a lot of valuable roles, such as in social care and in refuse work. And the regulations are going to give those workers the right to the same basic working and employment conditions as if they've been employed directly by the authority. Now, what this means in practice is that they're going to get the right to the same pay as a comparable employee. So the regulations in some cases will mean an increase in the cost of agency workers.
Does this mean that agency workers will be entitled to all the same terms and conditions as employees?
No, the right is to the same basic working and employment conditions. Now, that does include pay, but it doesn't include occupational pension and sick pay. So there'll still be some savings there when compared to an employee. Also, many of the rights are subject to a 12-week qualifying period. So where you've got agency workers who are only working for a short-term period, the impact of the regulations will be minimal.
Phil, you mentioned a 12-week qualifying period, and that's obviously really key to these regulations. How is that going to be calculated?
Well, first of all, any period of work in a calendar week, be that part-time or full-time, will count as 1 week when you're adding up the 12 weeks. Also, if there are repeat hires, so you've got a worker that works for you in one assignment, goes away and then comes back to you in the same type of role, then if there's a break of more than 6 weeks, the clock is reset at week 1 when they return. The clock will also be reset if the agency worker starts a substantially different role with the same authority, and that will be the case whether or not there's a break between the two roles. Finally, if someone doesn't work for a number of specified reasons, such as because they're off sick or because of school closure periods, then the clock is paused during that period of absence rather than the clock being reset if they're away for more than 6 weeks.
What do local authorities need to do now to prepare for these regulations coming in on the 1st of October next year?
Well, the main thing is they need to have a look at their use of agency workers, work out how much these regulations are going to cost them, and to do that what they'll need to do is have a look at what they pay agency workers, work out how many agency workers they've got, and work out the typical length of an assignment. Is it 12 weeks or more? Now, when they've done that, they may find that actually the cost impact of the regulations is minimal, because remember, in many cases, agency workers are paid more than a comparable employee, and the regulations don't give employees any rights, so they won't have the right to be paid the same as a higher paid agency worker. The second thing that authorities should do is work closely with their employment agencies to make sure that those agencies have got all the information about the terms and conditions in the authority, so they can then make sure that the agency worker gets the right rate of pay.
So where can local authorities go to find out more information about these regulations?
Well, the first port of call should be our website. There are some useful FAQs on there which give some tips to local authorities on how they can prepare for the implementation of the regulations. Secondly, the government will be consulting on guidance to accompany the regulations, and that's expected early next year. So authorities should look out for information on that on our website in the consultation section, and they can then feed our comments into us, which we can feed back to the government. So one of the first things the coalition government said they would do was remove the default retirement age. So what's happening with retirement?
Yes, the lawful compulsory retirement that employers were allowed to use under the age regulations that were introduced in 2006, that's being removed. What that means is the default retirement age and the statutory retirement processes will be removed through a transition process from the 6th of April to 1st of October next year. So things like the duty to notify employees of their intended date of retirement and the duty to consider any requests to work beyond retirement age, they're going to disappear.
So will this mean a big change for how local authorities manage retirement?
Yes, although the government will introduce a new compulsory retirement process called the Employer Justified Retirement Age from the 1st of October, it's likely there will be a lot fewer opportunities to actually compulsory retire an employee. And the effect of that is that employees will now have more choice about when they want to retire. Most people will probably still choose to retire when they can afford to do so, when they reach pensionable age. But in terms of the employer deciding when to retire someone, that's going to be a lot less frequent now.
Can you tell us more about how this employer justified retirement age will work?
Yeah, the Employer Justified Retirement Age, it's a new process for compulsory retiring employees, and it's going to work under the age discrimination framework that's moved into the Equality Act. Now, compulsory retirement will remain direct age discrimination, but age discrimination has retained its unique ability to be justified under the Equality Act. What an employer would have to show to justify that compulsory retirement is that it is a proportionate means of achieving a legitimate aim, and that sounds quite fancy, but what that really means is the employer will have to show that the discriminatory act was far outweighed by the benefits to the organisation of doing it, for example, sort of health and safety or reasons like that, or they'll have to show that they had no other way of achieving the same outcome for the business. The recent Court of Appeal case for Selden and the recent European Court of Justice case for Rosenblatt and Ollerking, they've given us some pointers on what could be justification for a compulsory retirement. For example, creating career progression opportunities for younger workers might be justification for compulsory retiring older workers.
So that's the new system, but how will employers manage retirement during the removal of the default retirement age?
The government have proposed quite a simple transition process, and there are 3 things that an employer will have to do to make sure any retirement under the transition remains a lawful retirement. Now, the first thing is that the employer will have to write and notify any employees coming up for retirement before the 6th of April 2011. And the second part of that is that any employees who have been notified of their retirement, that retirement has to take effect before the 1st of October 2011. So those employees who are reaching their 65th birthday or older than their 65th birthday will be able to be retired before the 1st of October next year. And the third thing is that employers need to remember to still use the statutory retirement processes. So that's, we were talking about the letters to notify someone of their retirement date and giving them between 6 and 12 months notice of that retirement. So what local authorities will need to do to manage this transition period is to look at who in their staff are coming up for their 65th birthdays or maybe older than their 65th birthdays during this transition period, and work out whether they want those employees to keep working to continue being in the workforce after the 1st of October next year.
Will there be any guidance for local authorities on managing retirement?
Yes, the government is committed to providing some support for employers for managing retirement issues. They've recently closed a consultation to ask what do employers want to support them in managing retirement issues. We contributed to that consultation on behalf of local government, and we've asked for some statutory guidance on managing retirement issues in the future. So we'll see what's going to come out of that. In the meantime, Local Government Employers is working on providing local authorities with a series of tools to help them manage older workers. Now, we're going to look at all sorts of issues for managing older workers, from recruitment to engaging older workers and also managing their exit, managing their retirement. This is a really big topic for local authorities and for our sector, because we have the oldest workforce of any sector in the UK. So we'll make sure that our website is fully up to date and has lots of advice and guidance on what the law is, and also some best practice for developing our policies and developing our practices for managing older workers. Phil, our last topic today is to look at the processes involved in changing terms and conditions of employment, and we know that's something a lot of local authorities are looking at the moment. Can you tell us what's the first step a local authority should take when they're looking to change terms and conditions?
Well, it might sound obvious, but the first thing to do is actually check whether the change they want to make is a change to the contract. Now, to do that, they should check written contracts to see what they say, but also have a think about what terms may be incorporated into the contract, say from a collective agreement. Now, the case of Malone and British Airways is a good example of this. We've reported the case recently, and the case is about the long-running dispute between British Airways and its cabin crew staff about BA's reduction in the number of cabin crew staff on flights. Now, there are minimum cabin crew numbers set out in a collective agreement, and the question was whether those minimum requirements in the collective agreement were incorporated into individuals' contracts, because if they were, when BA reduced the numbers, they would have been in breach of contract.
So what did the Court of Appeal decide for the British Airways case?
The Court of Appeal said no, the provision about minimum staffing requirements is a collective one only, it's not in individuals' contracts. Now, the reason for this was because if they had been in individuals' contracts, they would have been contractually entitled not to work on a flight whenever those minimum levels were breached. The consequences of that for BA would have been pretty serious because lots of flights could have been cancelled at short notice. Now, as the provision was in the collective agreement, it was binding in honour only, which meant that the consequences for British Airways were industrial relations ones rather than breach of contract ones.
For British Airways, the change wasn't contractual, but what if it is contractual? What are the next steps to take then?
The next step is to have a look at the contract to see whether there's a clause that allows the authority to vary the contract. If there is such a variation clause and what they want to do falls squarely within the terms of that clause and the authority consults on and gives adequate notice of the change, then they can use the clause to make the change. However, in many cases there won't be that type of clause, so authorities should try and seek agreement to the change. That can either be on an individual basis with individual employees, or more often it will be on a collective basis through negotiation with the trade unions. And a crucial part of that is making sure that they explain the reasons for the change, as you're more likely to get agreement if it's clear why you need to make that change.
But what if agreement can't be reached? Can an employer still go ahead and change terms and conditions of employment?
Yes, they can through the process of dismissal and re-engagement on new terms. Now, if an authority decides to take that route, they need to plan the process very carefully, taking into account the statutory consultation procedures. Now, what this means is that if 20 or more employees will be dismissed and re-engaged on new terms within a period of 90 days, you have to allow at least 30 days for consultation with trade union reps. If you've got 100 or more employees involved, then you've got to allow at least 90 days consultation. Now, these are technical provisions, there's lots of detail on it, so I'd recommend that authorities have a look at our e-guide on variation of contracts that gives a lot more information on this process. To round up though, what we'd always want to stress is the focus should be trying to get agreement through negotiation, and dismissal and re-engagement should only be used where agreement cannot be obtained.
Thank you for watching. You'll find more information on all the topics we've talked about today on our website, and our next podcast will be broadcast in March 2011, and also in March we'll be running our annual employment law seminar for local government, and you'll find details of that on our website on the events page. But until then, goodbye.